Hello and welcome. You're listening to a special intensive session of The Deep Dive brought to you exclusively by Swadharma IAS Academy.
I am your lead lecturer for this module, and today we are going deep. We're not just skimming the surface, we are undertaking, really, a surgical analysis of one of the most critical pillars of Indian democracy, the judiciary.
That's right, and our objective today is singular and sharp, to provide you with a comprehensive, high-yield conceptual framework, one that is designed specifically for the rigorous demands of the UPSC Civil Services examination.
And I'm joining you as a senior aspirant. I've spent, years navigating the maze of Laxmikanth, D.D. Basu, and the bare acts themselves.
So your role today isn't just to listen, but to really represent the confusion, the doubts, and the connecting dots that can plague every serious student.
I'm here to flag the areas where the examiners love to twist the language, to make sure we don't just memorize the articles, but that we actually understand the logic behind them.
Excellent. Now, before we dive into this constitutional labyrinth, a standard but absolutely vital reminder to all our students watching.
Please, watch this lecture right to the very end for complete conceptual clarity. The judiciary is a topic where, frankly, half knowledge is dangerous.
It really is. And of course, don't forget to like, share, and subscribe to Swadharma IAS Academy. It really helps support this educational initiative. Okay, let's begin.
So, to start, we usually study the Constitution in parts, right? Union executive, state executive, and so on. And we tend to think of the judiciary in that same sort of fragmented way.
Yes, Part V for the Supreme Court, Part 6 for the High Courts.
But I seem to recall a specific observation by Dr. B.R. Ambedkar that directly contradicts this federal division.
You are hitting the nail on the head right at the start. That's the perfect place to begin. When we talk about the judiciary in the Indian Constitution, yes, textually, you're right. We look at Part V for the Union and Part 6 for the states.
But that's not the whole story.
Not at all. Conceptually, you must burn this phrase into your memory. India possesses a single, unified, and integrated judicial system.
A single, unified, and integrated system.
This is a massive departure from, say, the American model. In the U.S., you have a federal judiciary that enforces federal laws, and then you have a state judiciary enforcing state laws. They are, for the most part, distinct silos.
That's the key confusion point for so many aspirants. Because in the U.S., the state Supreme Court is the final word on state laws. But here we have a pyramid. A very clear hierarchy.
Precisely. It is a pyramid structure. At the absolute apex, you have the Supreme Court. Below it, you have the High Courts. And below them, an entire structure of subordinate courts.
And this is the integrated part you mentioned.
Yes, this is the crucial bit. This entire hierarchy administers both union and state laws. A district judge in a remote part of Tamil Nadu applies the Indian Penal Code, which is a central law, just as they would apply a local state rent control act.
And the Supreme Court, sitting at the top of that pyramid, can correct that judge on their interpretation of both of those laws.
Exactly right. It's fascinating, really, because it reflects the so-called unitary bias of our Constitution. The Founding Fathers were, and this is well documented, terrified of what they called centrifugal forces.
These tendencies that could tear the newly formed nation apart.
Yes. They wanted the judiciary to be the cement, if you will, holding all the bricks of the federation together.
That is a beautiful analogy. The judiciary is the cement.
And this is why, as we'll see later on, the parliament, a central body, has the power to organize the high courts, which are technically state-level institutions. It's why the president, the head of the union executive, appoints high court judges.
The entire system is designed to prevent what you could call provincialism in the delivery of justice.
Correct. And for those of you listening, this concept of integration is extremely high yield for Maine's GS Paper 2. It's a standard question to compare Indian and American judicial federalism.
But for prelims, the devil is, as always, in the details of how this pyramid was actually built.
Which brings us very neatly to our Section 1, Historical Evolution and Constitutional Basis. We simply cannot understand the Supreme Court of 1950 without understanding the ghosts of 1773. The lineage is absolutely crucial.
The Regulating Act of 1773, this is something we often study in history, but in polity, I think we sometimes overlook its real significance. It established a Supreme Court at Fort William in Calcutta. But, sir, That court was a terror, wasn't it?
It was a chaotic and frankly terrifying experiment. It was established in 1774, and it had a Chief Justice, Elijah Impey, and 3 other judges, but the British didn't clearly define its jurisdiction.
So it was constantly clashing with other authority.
Constantly. It clashed with the Governor-General, Warren Hastings. The most infamous example, of course, is the trial of Raja Nandkumar.
Right, where the Supreme Court applied English law to an Indian local in a manner that many historians now call a judicial murder.
A judicial murder. It's a stark term, but it reflects the reality. This chaos, however, actually taught the future lawmakers a very important lesson. You need to have clear jurisdictional boundaries.
And that evolution continued, but slowly. We eventually got the Indian High Courts Act of 1861, which is really the grandfather of our current high court system.
Yes, that act established the high courts in Calcutta, Bombay, and Madras.
But the direct ancestor of our current Supreme Court isn't that 1773 court in Calcutta. It's the federal court, right, from the 1935 Act.
That is correct. The Government of India Act, 1935, which was this mammoth piece of legislation, envisaged a federal structure for India. And to resolve disputes between the provinces and the center, they established the Federal Court of India in 1937.
And it sat in Delhi.
It did. It sat in Delhi. It had a fairly limited jurisdiction, but it was the first true all-India court.
But here's the catch, and it's a detail that examiners just love to play on. The federal court wasn't the final court of appeal.
No, it wasn't.
If you lost your case in the federal court in Delhi, you could still pack your bags and head to London.
Exactly. The Privy Council in London, specifically the Judicial Committee of the Privy Council, remained the highest court of appeal for the colonies. And this is a fundamental point of sovereignty.
As long as the Privy Council was the final arbiter.
India's judicial sovereignty was incomplete. This only changed when the Supreme Court of India was inaugurated on the 28th of January, 1950.
Just 2 days after we became a republic.
Yes. And on that day, the Supreme Court of India replaced both the federal court and the British Privy Council. It absorbed the jurisdiction of both institutions.
Which is why our Supreme Court is, in some ways, even more powerful than its American counterpart.
In terms of appellate jurisdiction, absolutely. It inherited the incredibly wide appellate powers that the Privy Council used to exercise.
So January 28, 1950, marks the true beginning of an independent Indian judiciary. Now, to geometrically locate this in the Constitution, we're looking at Articles 124 to 147 in Part 5.
That is the textual fortress, as I like to call it. Article 124 starts with the powerful words, "There shall be a Supreme Court of India." These articles cover everything: organization, independence, jurisdiction, powers, procedures.
And while Parliament can regulate some of the finer details.
The core of these articles, the very essence of judicial independence, has been declared by the court itself to be part of the basic structure of the Constitution, meaning even Parliament, with a special majority, cannot touch it.
Which is a perfect segue to Section 2, the Supreme Court composition and appointments. This is, without a doubt, the most politically charged and exam-relevant section we'll discuss today. The numbers have changed, and the method has certainly changed.
Let's tackle the numbers first, the strength of the court. In 1950, the Constitution fixed the strength at 1 Chief Justice and 7 other judges, a total of 8.
Which today seems minuscule, just tiny, given our population and the volume of litigation.
We are a very litigious society, it's true, so the number had to go up.
And it did, repeatedly.
It did. It was increased in 1956, then 1960, 1977, 1986, 2008, and most recently in 2019. The strength was increased step by step. Currently, the sanctioned strength is 34. That's 1 Chief Justice plus 33 other judges.
Okay, I want to pause on the mechanism here, because I've seen aspirants get very confused about this. They think that because the president appoints the judges, the president also decides how many judges there should be. But that's incorrect.
Yeah, that is a classic error. The power to increase the number of judges is vested exclusively in the Parliament, and they must do it by enacting a law.
It requires a legislative act, not just an executive order from the president's office.
Exactly. And the reason is both financial and structural. Judges' salaries are charged on the Consolidated Fund of India, and Parliament controls the purse strings. So Parliament decides how many judges there should be, but the executive and the judiciary together decide who those judges will be.
And that who is the controversy of the century, isn't it? The Collegium system. If I do a Ctrl plus F search on a PDS of the Constitution of India for the word Collegium, I get 0 results.
You get 0 results because it is a purely judicial invention. It is a child of case law, not of the original constitutional text.
So what does the text actually say?
Article 124, Clause 2, simply says that the president shall appoint judges after consultation with such judges of the Supreme Court and high courts as he deems necessary.
Just consultation.
Just consultation. The drafters, in their wisdom, thought consultation was a polite and sufficient word. They clearly didn't foresee the immense power struggle that would erupt over its meaning.
And this struggle played out in the famous 3 judges cases, or 4, really, if we count the NJAC case. We absolutely need to map this timeline because the balance of power shifts like a pendulum.
Let's trace that arc very carefully. It starts with the first judge's case in 1982, also known as the S.P. Gupta case. Now, the context here is critical. This was post-emergency India.
Right. The judiciary was still somewhat demoralized, and the executive was extremely dominant.
Precisely. The Supreme Court, in what some have called a moment of self-abnegation, ruled that consultation does not mean concurrence.
Meaning the government just have to ask, but it doesn't have to agree.
Exactly. It essentially said that the president, which means the executive, is the ultimate decision maker. The Chief Justice of India's opinion could be respectfully heard and then completely ignored.
So the 1980s were the era of executive primacy in judicial appointments. Political considerations could and did play a bigger role.
Yes. But the pendulum swung back, and it swung back violently in the second judge's case of 1993. This is the Supreme Court Advocates on Record Association case.
And here, the court completely overruled its 1982 judgment.
Completely. They performed a linguistic and constitutional interpretation that is still debated by strict constructionists to this day. They held that in the unique context of judicial appointments, consultation must mean concurrence.
So asking became agreeing. And the logic was, I suppose, that the CJI is the expert on the legal competence and integrity of a potential judge, not the prime minister or the law minister.
That was the core of their reasoning. They held that the CJI's advice, given after consulting his senior colleagues, is binding on the president. And this judgment birthed the Collegium. At that time, it was the CJI plus the 2 senior-most judges.
But then some confusion arose about the internal workings of this new body. Can the CJI just dictate terms to the other 2? Is his opinion the only one that matters?
Yeah.
This led to the third judge's case in 1998.
Correct. The president, exercising his power under Article 143, which is the advisory jurisdiction, asked the Supreme Court to clarify these points. And the court's opinion in this case expanded and, in a way, democratized the Collegium.
How so?
They said the CJI must consult the 4 senior-most judges of the Supreme Court. The body became larger. And, very importantly, they said that the CJI's opinion is not his individual opinion, but the collective opinion of this institutional body.
So if some of the other senior judges disagree?
The court clarified that if 2 of the judges give an adverse opinion, the CJI should not send the recommendation to the government. This created the system we have today. The CJI plus 4 senior-most judges for Supreme Court appointments.
So, just to trace it, from executive supremacy in 1982, we swung to judicial supremacy in 1993, and then to what we could call a plurality of judges model in 1998. But the story has a final, very dramatic twist. The government tried to fight back in 2014 with the NJAC.
The National Judicial Appointments Commission. This was the 99th Constitutional Amendment Act. And it was a rare moment of political consensus where the ruling party and the opposition in Parliament completely agreed.
They both wanted to replace the opaque, closed-door Collegium system with a more transparent commission.
Yes. The proposed commission was to have the CJI, 2 other senior judges, the union law minister, and 2 eminent persons to be selected by a high-powered committee.
On paper, it looks like a very reasonable system of checks and balances, a mix of judicial, executive, and civil society members. But the Supreme Court saw a Trojan horse.
Precisely. In the 4th judge's case of 2015, a 5-judge Constitution bench struck down the 99th Amendment by a 4.1 majority. Their reasoning was anchored firmly in the basic structure doctrine.
They argued that the presence of the law minister, an active member of the executive,
and the eminent persons in the appointment process compromised the independence of the judiciary. The argument was, if the executive has a say, or even a veto, on who becomes a judge, then judges might be tempted to rule in favor of the executive to secure promotions or post-retirement appointments.
So they declared the entire NJJC unconstitutional and void.
They did. Which brings us back to square one. The Collegium system, which was created by the 2nd and 3rd judges' cases, stands. It remains the only system in the world where judges appoint judges.
And it continues to be heavily criticized for its opacity and alleged nepotism. But as of today, it is the law of the land.
It is the law of the land. Now let's look at the qualifications to become one of these powerful judges. Under Article 124, Clause 3, what do you need?
First, you must be a citizen of India. That's non-negotiable.
Of course. Then comes the professional experience. There are 3 possible routes. First, you could have been a judge of a high court or multiple high courts for at least 5 years.
Or second, you could have been an advocate of a high court for at least 10 years.
Or, and this is the most interesting and least used one.
The distinguished jurist clause.
Yes. In the opinion of the president, a distinguished jurist. This could be a brilliant law professor, a legal scholar, someone who has written authoritative books on the Constitution but has never argued a single case in court.
But here's the crucial nuance, the preliminary trap, if you will. This clause exists only for appointment to the Supreme Court. You cannot become a high court judge via the distinguished jurist route. Why is that?
Well, the logic is that the Supreme Court deals with grand questions of constitutional interpretation, the philosophy of law, and abstract jurisprudence, where a deep academic perspective could be invaluable.
Whereas the high courts are primarily courts of appeal for everyday civil and criminal cases.
Exactly. They need judges with practical procedural experience of how trial courts function. What's truly interesting is that despite this clause existing since 1950, no distinguished jurist has ever been appointed to the Supreme Court in India's history. It remains a theoretical door that has never been opened.
Another small point students often look for is a minimum age. There is none prescribed in the Constitution, is there?
No. Theoretically, if someone becomes a high court judge at, say, 40 and serves for 5 years, they could be eligible for the Supreme Court by 45.
But given the conventions of seniority, that rarely ever happens.
It's highly improbable in the current system. Okay, let's move to Section 3. Tenure, removal, and independence. Once you are in until the age of 65.
Yes. The tenure for a Supreme Court judge is until they attain the age of 65 years. For high courts, as we'll see, it's 62.
If they wish to resign, the resignation is addressed to the president. And the oath, which is administered by the president or someone appointed by him, is very weighty. They swear to uphold the sovereignty and integrity of India and, crucially, to uphold the Constitution and the laws.
Now let's talk about the security of this tenure, the removal process. The media often uses the word impeachment.
They do, and it's a common shorthand. Strictly speaking, the Constitution uses the word impeachment only for the president under Article 61. For judges, the term used is removal. But the process is so similar and so rigorous that we often use the terms interchangeably in common parlance.
And it is an incredibly difficult process designed to be so.
Yes, and for good reason.
Yeah.
A judge should not be looking over their shoulder at the parliament every time they pass a judgment that is unfavorable to the government of the day.
So how does it work?
The process is laid out in Article 124, Clause 4, and it's further detailed in a separate law passed by Parliament, the Judges' Inquiry Act of 1968.
And the grounds are very specific. You can't just remove a judge for being unpopular.
Not at all. The only grounds are proved misbehavior or incapacity. And the word proved is key.
Let's simulate the process. I am a member of Parliament, and I believe a judge is guilty of misbehavior. What's the first step?
You can't do it alone. Step 1 is you need to gather support and get a motion signed by 100 members if you are in the Lok Sabha, or 50 members if you are in the Rajya Sabha.
So there's a numerical threshold right at the beginning.
Yes. Then, step 2, you present this motion to the Speaker of the Lok Sabha or the Chairman of the Rajya Sabha. Step 3 is critical. The Speaker or the Chairman has the discretion to either admit the motion or refuse to admit it. They act as a crucial gatekeeper.
This happened in the case of former CJI Deepak Misra, didn't it? The opposition parties moved a motion in the Rajya Sabha.
And the Vice President, who is the Chairman of the Rajya Sabha, refused to admit it at the very threshold, saying there wasn't enough merit. So the process ended right there.
Well, let's say it is admitted. What happens then?
If it's admitted, step 4 kicks in. The presiding officer constitutes a 3-member inquiry committee to investigate the charges. This committee is composed of 1, the Chief Justice, or a judge of the Supreme Court, 2, a Chief Justice of a High Court, and 3, a distinguished jurist.
So the investigation itself is judicial in nature, not political. It's judges investigating a judge.
That's the principle. And if this committee finds the judge guilty of misbehavior or incapacity, then its report is laid before the House where the motion originated.
And then the voting begins.
Yes. Now comes the really high hurdle. The motion must be passed by a special majority in both houses of Parliament, and it must be done in the same session.
Can you break down what special majority means here?
It means 2 conditions must be met simultaneously. First, a majority of the total membership of the House, which is called an absolute majority, and second, a majority of not less than 2/3 of the members of that House present and voting.
That is an impossibly high bar to clear in today's era of coalition politics. Has it ever actually happened?
Never. No judge of the Supreme Court or a high court has ever been successfully removed through this process. The closest we ever came was in the case of Justice V. Ramaswamy in the early 1990s.
What happened there?
The inquiry committee, set up under the Act, actually found him guilty of serious financial irregularities during his time as Chief Justice of the Punjab and Haryana High Court. The motion for his removal was introduced in the Lok Sabha, but the ruling Congress party at the time decided to abstain from voting.
So even though the opposition voted for removal,
Because a large block of MPs abstained, the motion failed to get the required support of the majority of the total strength of the House. The motion fell. It really shows that while the inquiry is judicial, the final act of removal is intensely political. It's a numbers game.
and in other cases, like Justice Sumitra Sen of the Calcutta High Court or Justice P.D. Dinakaran, they ended up resigning before the parliamentary process could conclude to save their dignity and, importantly, their post-retirement benefits.
Indeed. This whole rigorous process is the primary safeguard for the independence of the judiciary. Let's just list the other safeguards briefly for our students.
Okay.
1. Fixed service conditions. Their salaries, allowances, and privileges cannot be changed to their disadvantage after their appointment, except during a financial emergency.
2. Their salaries and expenses are charged upon the Consolidated Fund of India.
Which means they are not subject to the annual vote of the Parliament. Parliament can discuss them, but not vote to reduce them.
3. The ban on practice after retirement. A retired Supreme Court judge cannot plead or act in any court or before any authority within the territory of India. This prevents them from potentially favoring future clients while they are still on the bench.
And finally, the power to punish for its contempt. This allows the court to maintain its authority, dignity, and respect.
That's a comprehensive list. Now let's pivot to Section 4, the jurisdiction of the Supreme Court. The Supreme Court wears many different hats. It's a federal court, a writ court, an appellate court, and even an advisory court.
Let's start with its role as a federal court, which is its original jurisdiction under Article 131. Now, the word original here means that you can go straight to Supreme Court with your case. No lower court needs to be involved.
And this is exclusively for federal disputes, right? Fights between different units of the Federation.
Exactly. It covers 3 types of disputes. 1, between the government of India and one or more states. 2, between the government of India and any state on one side and one or more other states on the other. And 3, between 2 or more states.
But there are some important exceptions that aspirants often miss. You can't just drag the central government to the Supreme Court under Article 131 for any and every disagreement.
Correct. The Constitution and various laws explicitly exclude certain matters. The most famous exclusion is interstate water disputes.
Article 262.
Yes, Article 262 empowers Parliament to create special tribunals for river water disputes, like the Kaveri or Krishna water disputes tribunals, and the law can state that the jurisdiction of the Supreme Court is barred in these matters.
What's the logic behind that? Why keep the highest court out of such important disputes?
Because river water disputes are often deeply socio-political and highly technical. They involve hydrology, agriculture patterns, and historical claims. The thinking is that these are better handled by specialized, expert bodies rather than through the rigid application of legal principles in a courtroom.
So that's one major exception. What else?
Also excluded are matters referred to the Finance Commission, certain adjustments of expenses and pensions between the Union and the states, and disputes arising out of pre-constitutional treaties and agreements.
Okay. Then we have the writ jurisdiction under Article 32. Dr. Ambedkar called it the very heart and soul of the Constitution.
He did, because under Article 32, the Supreme Court is the designated guarantor and protector of our fundamental rights. It can issue 5 powerful writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto.
Now, senior aspirant, this is a perfect opportunity for you to explain the difference between the writ jurisdiction of the Supreme Court under Article 32 and that of the High Courts under Article 226. This is conceptual goldmine for the exam.
It is, and it's quite counterintuitive. In one crucial respect, the High Court's writ jurisdiction is actually wider than the Supreme Court's.
Wider? How so?
The Supreme Court can only issue writs for the enforcement of fundamental rights, which are in Part 3 of the Constitution. That's its mandate under Article 32.
Okay.
The high courts, under Article 226, can issue writs not only for fundamental rights, but also for any other purpose. This phrase, for any other purpose, means they can issue writs to enforce ordinary legal rights as well.
So if a statutory body violates a rule that isn't a fundamental right, I could go to the High Court, but not necessarily the Supreme Court?
Precisely. However, there's another side to it. Going to the Supreme Court under Article 32 is itself a fundamental right. So if your fundamental right is violated, you can go straight to the SC, and they must hear you. They cannot refuse.
Whereas approaching the High Court under Article 226 is discretionary, the HC might say, no, there's an alternative remedy available. Go to a lower court first.
Exactly. So, to summarize, the SC's jurisdiction is narrower in purpose, but is a fundamental right itself. The HC's jurisdiction is wider in purpose, but is discretionary.
That's a brilliant summary. Territoriality is also a factor, of course. The Supreme Court's writs run throughout India, while the High Court's jurisdiction is generally limited to its state.
Correct. Next up is the vast appellate jurisdiction. This is where the SC hears appeals against the judgments of the High Courts in constitutional, civil, and criminal matters. This is standard stuff, but the real wild card here is Article 136.
The Special Leave Petition, or SOP.
This is what I call the injustice buster. It is the residuary power of the Supreme Court. It's a purely discretionary power to grant special leave to appeal against any judgment, decree, determination, sentence, or order from any court or tribunal in the territory of India.
The scope is incredibly wide. Any judgment, any court.
Incredibly wide. If the Supreme Court feels that there has been a gross miscarriage of justice or a substantial question of law is involved, it can use Article 136 to bypass all normal procedural hurdles and hear the case directly.
Is there any exception at all?
Yes, just one. It cannot be used against a judgment passed by a military tribunal or a court-martial. The Supreme Court respects the autonomy and discipline of the armed forces judicial system.
Okay, and the last major type of jurisdiction is advisory jurisdiction under Article 143. This is where the president asks the court for its opinion.
Yes. There are two categories here. First, the president can refer any question of law or fact of public importance. In this case, the president may ask, and the Supreme Court may refuse to give its opinion.
Has the court ever refused?
Yes. In the Ayodhya reference case in the 1990s, the president asked a specific historical question about whether a temple existed at the site. The Supreme Court refused to answer it, saying it was not the job of the court to conduct a historical inquiry.
And the second category?
The second category involves disputes arising out of pre-constitutional treaties or agreements. Here, if the president refers the matter, the Supreme Court must give its opinion. It is mandatory.
And in both cases, is the advice binding on the president?
Crucially, no. The advice is never binding. It is just an opinion which the government can choose to follow or ignore.
Let's move down the pyramid now to Section 5. High courts. We have an integrated judiciary, but the high courts are not just, glorified subordinate courts. They are constitutional courts in their own right.
Absolutely. They're covered from Articles 214 to 231. We currently have 25 high courts for 28 states and 8 union territories.
Which means some high courts serve more than one state or UT?
Correct. This consolidation is possible because of the 7th Constitutional Amendment Act of 1956, which authorized Parliament to establish a common high court for 2 or more states or for a state and a union territory.
A great example is the High Court at Chandigarh, which serves Punjab, Haryana, and the Union Territory of Chandigarh.
Exactly. Now, the appointment process for high court judges mirrors the Supreme Court. It's the Collegium system. But let's talk about something I call the pension trap. This is a favorite topic for the UPSC examiner.
Okay, I'm listening. The pension trap.
Pay close attention to this. A high court judge works for a specific state, so his salary is drawn from the consolidated fund of the state.
That makes sense.
However, when that judge retires, his pension is charged upon the consolidated fund of India, meaning the central government pays it.
Now that is interesting. Why this split? Why doesn't the state that paid his salary also pay his pension?
The reason is that high court judges are transferable. A judge might be appointed to the Kerala High Court, serve there for 5 years, then be transferred to the Gujarat High Court for 5 years, and finally retire from the Delhi High Court.
I see. So if the states had to pay the pension...
Yeah. They would fight over who pays what share. He worked for you longer, you pay more. To avoid this undignified situation and to ensure that a judge feels secure and is willing to accept transfers in the national interest, the Constitution makers wisely decided to place the pension burden on the center.
That makes perfect logistical and constitutional sense. It reinforces their independence from state politics. And what about their removal?
The process for removing a high court judge is identical to that of a Supreme Court judge. Article 217 clearly states that a high court judge is removed in the same manner as provided in Article 124, Clause 4.
Which means the motion has to be moved in Parliament.
Yes, and this is another crucial point for prelims. The state legislature has absolutely no role in the removal of a high court judge. Only the Parliament of India can do it. Again, this reinforces the integrated nature of our judiciary. The state pays the salary, but it cannot fire the judge.
Let's descend the pyramid one last time to Section 6. Subordinate courts and tribunals. This is where the common citizen interacts with the justice system. This is the grassroots.
Indeed. These are covered in Articles 233 to 237. This is the district judiciary. The highest judicial authority in a district is the district judge.
And who appoints the district judge?
The appointment is made by the governor of the state in consultation with the high court of that state.
Note the shift. For the Supreme Court and high courts, the appointing authority was the president. For the district judge, it's the governor.
Correct. And for appointments of persons other than district judges to the judicial service, for example, the entry-level civil judge, junior division, the process usually involves the governor, the State Public Service Commission, SPSC, and the high court.
But the key article here, the one that ensures separation of judiciary from the executive at the lower level, is Article 235, isn't it?
Yes, Article 235 is the linchpin. It vests the control over the subordinate courts in the respective high court. This includes matters of posting, promotion, grant of leave, and disciplinary control.
So the executive, through the governor, might make the initial appointment.
But once a person enters the judicial service, their entire career is managed and controlled by the high court. This effectively implements the directive principle in Article 50, which calls for the separation of the judiciary from the executive.
Now, what about tribunals? They seem to be a parallel track of justice.
They are. This is Part 40A of the Constitution, which was added by the infamous 42nd Amendment during the emergency, based on the recommendations of the Swaran Singh Committee.
And it has two articles, 323A for administrative tribunals and 323B for other types of tribunals.
Right. 323A allows for the creation of administrative tribunals like the Central Administrative Tribunal, a CAT, and State Administrative Tribunals, SATs, to deal exclusively with service matters of government employees.
The idea was to offload this huge burden of service litigation from the high courts. But did it actually work as intended?
Well, it created a new problem. Initially, the law stated that if you were unhappy with a C judgment, your only appeal was directly to the Supreme Court. This completely bypassed the High Court.
That seems like a major disruption of the judicial hierarchy.
It was. And in the landmark L. Chandra Kumar case of 1997, the Supreme Court struck this provision down. The court ruled that the power of judicial review by the high courts under Articles 226 and 227 is part of the basic structure of the Constitution.
So Parliament can't just legislate it away.
Exactly. You cannot strip the High Court of its power of superintendence over all courts and tribunals within its territorial jurisdiction. So now the correct hierarchy is you go from the tribunal to a division bench of the concerned High Court, and only then can you appeal to the Supreme Court.
Which restored the primacy of the high courts in the judicial structure. Okay, finally, let's look at some modern innovations in Section 7. ADR and LS. The courts are drowning in pending cases. I believe the number is somewhere around 4 to 5 crore. We desperately need an exit valve.
That exit valve is Alternative Dispute Resolution, or ADR. And the main statutory framework for this is the Legal Services Authorities Act of 1987. This act established the National Legal Services Authority, NLS.
And this was done to fulfill the constitutional mandate of Article 39A, which is a directive principle calling for free legal aid to the poor.
Correct. And under this act, we have the institution of Lok Adalats. I've often seen these wonderfully termed as people's courts.
That's a great term for them. How do they work?
Lok Adalats are revolutionary in their simplicity. They can handle cases that are already pending in regular courts or even disputes that are at a pre-litigation stage. The core philosophy is compromise.
So it's not adversarial. There's no winning or losing an argument.
Precisely. The goal is to reach an amicable settlement that both parties can agree to. And because it is a compromise, a settlement reached by mutual consent, the award passed by a Lok Adalat is deemed to be a decree of a civil court and is final and binding on all parties.
Final and binding. And crucially, no appeal lies against the award of a Lok Adalat.
That sounds a bit dangerous. What if you're forced into a bad compromise? No appeal at all.
Well, think about the logic. If you and I voluntarily agree to a compromise, why would we then need to appeal it? If we don't agree, the Appellate cannot force a decision upon us. It simply sends the case back to the regular court to be decided on merits. The no appeal clause is only to ensure finality for settlements that are reached with consent.
That makes sense. And what about Graham-Nyalayas?
These were established under the Graham-Nyalayas Act of 2008. The idea is to provide justice at the doorstep in rural areas. These are mobile courts presided over by a Nyadhikari who travels to villages.
And they can try both civil and criminal cases.
Yes. And crucially, they are not bound by the strict rules of the Indian Evidence Act of 1872. They are guided by the broader principles of natural justice. This allows them to cut through complex legal technicalities and deliver Nyaya justice in a manner that is quick, affordable, and understandable to the rural population.
This brings us to our final section, wrapping up with Section 8, Judicial Concepts. We hear terms like judicial activism, judicial review, and PIL thrown around in the news all the time.
Let's quickly define them with clarity. Judicial review is the most basic power. It is a power of the judiciary to examine the constitutionality of legislative enactments and executive orders. If a law violates the Constitution, the court can declare it null and void.
Its origins are in the American case of Marbury v. Madison, and in India, it's considered part of the basic structure.
Correct. Now, judicial activism is when the judiciary steps out of its traditional passive role and takes on a more proactive role in protecting the rights of citizens and promoting justice, especially when the other two organs of the state, the legislature and the executive, are failing in their duties.
Can you give an example?
The classic examples are the MC Mehta cases, where the Supreme Court passed a series of orders to control pollution in Delhi when the executive was failing to act, or the Vishaka Guidelines, where the court laid down rules to prevent sexual harassment at the workplace because Parliament had not yet passed a law. It's essentially filling a vacuum.
But there's a very thin line between positive activism and negative overreach, isn't there?
There is. Judicial overreach is when the judiciary starts encroaching upon the proper domain of the legislature or the executive, when the court starts getting into policy making. Banning liquor shops on highways, deciding the height of Dahihandi pyramids during festivals, managing the cricket board, BCCI.
Critics argue these are policy matters or administrative tasks, not legal questions for a court to decide.
Exactly. Overreach disrupts the delicate balance of separation of powers.
And the main vehicle for both activism and, at times, overreach has been the PIL, public interest litigation.
Yes. Before the 1980s, we had the strict rule of locus standi. This means only the person who was directly affected or victimized could go to court.
But two pioneering judges, Justice V.R. Krishna Iyer and Justice P.N. Bhagwati, changed this.
They did. They relaxed the rule of locus standi. They said, if a victim is too poor, too ignorant, or too oppressed to knock on the doors of the court, any public-spirited citizen or social action group can move the court on their behalf.
This completely democratized access to justice. It started with the rights of prisoners in the Husinara Khatun case, which established the right to a speedy trial as a fundamental right.
And it expanded from there to cover almost every issue imaginable: environmental protection, bonded labor, corruption, rights of children. It truly transformed the Supreme Court from being just a traditional court of appeal into a Supreme Court for all Indians.
Sir, we have really covered the entire spectrum today, from the Colonial Regulating Act to the modern PIL, from the institutional rigidity of the Collegium to the procedural flexibility of the Graham-Nyalaya.
Indeed. The Indian judiciary is a complex, powerful, and constantly evolving organism. It is designed to be independent, to be integrated, and increasingly to be inclusive.
To summarize for our students taking notes,
remember, it is an integrated system, a single hierarchy for all laws, both central and state.
2. Appointments are made through the Collegium, a system of judges appointing judges, designed to secure independence from the executive.
3. The removal process is via Parliament with a very difficult special majority, designed to secure their tenure.
4. In terms of jurisdiction, remember the key differences. The Supreme Court has exclusive federal jurisdiction, but a narrower writ jurisdiction than the high courts. And don't forget the wild card of Article 136.
And 5. Modern reforms like Nalesa, Look Adelants, and Graham-Nyalayas are the way forward to tackle the huge problem of case pendency.
My final tip for all the aspirants would be this. Don't just memorize the articles. Try to understand the tension between the institutions. The conflict between Parliament and the judiciary over appointments, which culminated in the NJAC case, is a classic mains question. The nuance of the governor versus the High Court in the appointment of district judges is a potential prelims statement.
That is precisely right. Keep your concepts clear, and the facts will naturally follow.
Thank you for attending this comprehensive lecture. We sincerely hope this deep dive provides the conceptual clarity you need for your exams.
And once again, a reminder, watch to the end for complete conceptual clarity, and please don't forget to like, share, and subscribe to Swadharma IAS Academy. Keep studying, stay curious, and Jai Hind.